Good morning, everyone, and welcome to our third episode of our on-site construction webinar series. This is the autumnal episode. So today I think we have a really good lineup, not least of all because we're discussing two recent important WFW cases, and we have the pleasure of being joined by both counsel instructed on those cases. So first up, we will be discussing a case that's been getting a lot of commentary, and that's the case of Triple Point Technology and PTT. And that we are joined by James Howells QC. James specializes in international commercial arbitration with particular expertise in infrastructure, construction, engineering, shipbuilding, and IT disputes. Much of his work is international, and he's advised on disputes in jurisdictions all over the world, including Hong Kong, Tanzania, and the Caribbean. Time won't permit me to list all of them, but I felt quite provincial reading through that list. James is described by the legal directories as a phenomenal silk, very user-friendly, hands-on barrister with formidable advocacy skills. Having represented PTT at first instance and through each of the appeals, WFW partner Rob Fidoe and James will discuss the decision and its implications for the interpretation of liquidated damages clauses, how liquidated damages are treated in a termination scenario, and also as an added bonus, limitation of liability provisions, which I think is always interesting. Next up, we have Where Next for Collateral Warranties, and Barry Hembling and Tom Owen will be discussing another WFW case, the case of Toppan Holdings Limited and Simply Construct. Tom Owen is recognized as one of the leading juniors at the Construction and Energy Bar. He's widely acclaimed in the legal directories and recognized as one of the most promising juniors at the bar. Legal Week's stars at the bar say he has everything you want of counsel. Tom has been nominated for Construction Junior of the Year at the 2021 Chambers and Partners Bar Awards, and he's particularly known for his advocacy and trial work. Toppan provides rare guidance on the nature of collateral warranties, and up until now, the established position was that, depending on the wording, I think most of us, thought it was fairly well settled that they would be considered construction contracts for the purposes of the Act. Not so. Following this decision, in which, and it's rare because two separate adjudicators' decisions were applied to be enforced at the same time during the same court proceedings, the court confirmed that the timing of execution of the collateral warranties is paramount in determining whether a statutory right to adjudication arises. The judgment obviously creates a lot of questions, and Barry and Tom are going to seek to make sense of what has been decided today. Last but definitely not least, Ryland Ash will be discussing the very hot topic of the impact of construction materials and labour shortage, how to protect your company when drafting contracts, negotiating them, and thereafter administering them. So that will be interesting as well. So without further ado, I will hand over to Rob Fidoe and James Howells.
Okay, thank you for that. So I'm going to look particularly at the liquidated damages section on this case. As many of you will know, the background to the matter is a contract for the design and implementation by Triple Point Technology of a new business software system to be used by PTT, the Thai government-owned oil major, who undertakes commodities trading across the globe. The system was to provide for commodities trading functionality, charter party management, and for hedging the trading risks that PTT exposed itself to on the global markets. It was, in fact, the first IT contract to be considered by the Supreme Court, as Lady Arden introduced it when she gave judgment. If we can take to the first slide, please. So on this slide, I've set out the clause which caused so much difficulty. I've underlined the bit that were the words that ultimately took us to the Supreme Court. It was a bespoke contract, not one we see elsewhere. It's not got standard form wording, but nonetheless, as you read the text underlined, you'll undoubtedly recognise the words themselves not particularly exceptionable. On to the next slide. As you'll be aware, many will be aware, the problems in this case started really at the Court of Appeal stage. It was the Court of Appeal judgment in 2019 as to the meaning of that clause and the approach that the court took to arriving at that meaning that gave rise to these significant concerns for the construction and engineering industries. In a widely reviewed and by some reviled judgment, the Court of Appeal suggested that liquidated damages clauses would fall into one of three categories and ought to be interpreted on that basis. Interesting, the decision itself was one which was almost entirely influenced by Sir Rupert Jackson, the TPT not having sought to argue the point either in writing or orally at the hearing until prompted by the judge. The three categories I've sought to summarise on the screen there. The Court of Appeal decided that the clause in this case rather fell into category 1, that the liquidated damages do not fall due until work's completed, or alternatively, if they do fall due, that entitlement is lost if the contract is terminated prior to completion. And that was the interpretation that caused a real problem in this case, and of course gave rise to considerable concerns for the future. While the court acknowledged that category 2, which was regarded as the orthodox approach and recorded as such by the court, was recognised, it implied heavily that many of the cases that have been decided on that basis, which it listed in the judgment, may be open to doubt for the fact that judges in those cases hadn't considered an old Scottish case called British Glanstoff. The Court of Appeal said that the British Glanstoff case, a 1913 case in the outer house and inner house of the Court of Session, and ultimately in the House of Lords, was the archetype for what it described as category 1, although rather unhelpfully didn't really explain why. Category 3 was discussed briefly, and I'll come back to that. It was based upon 2 English cases and a Hong Kong case. The Court of Appeal doubted those, but didn't expressly overturn them. The decision having been given, PTT appealed, challenging both the approach and the result. And as set out on the next slide, the Supreme Court were unanimous on this part of the appeal and the decision on liquidated damages. There were 2 reasoned judgments on the appeal, on this part of the appeal, from Lady Arden and from Lord Leckett, all the other judges agreeing. Both, in their own terms, were critical of the Court of Appeal attempt to categorise liquidated damage clauses and to find that one of those clauses, around one here being category 1, was to be found in the Glanstoff decision. Lady Arden, giving the lead judgment, criticised the Court of Appeal for its radical reinterpretation of the case law based on the little-known case of Glanstoff. Those are her words. The Supreme Court's decision has been welcomed for its confirmation of the orthodox approach, that's category 2 in the Court of Appeal's language, to the interpretation of liquidated damages. And in one sense, that does the judgment injustice. It suggests that all that the law lords did was to reconfirm category 2. But as set out in the quotes on the next slide, the Supreme Court arguably went further, I would suggest, setting out clear guidance that the commercial purpose for an LD's clause is to give predictable and certain results for defined events of breach, often but not always delays in completion. As Lady Arden explained, the commercial purpose is key to the interpretation of a clause like Article 5, the liquidated damages clause in this case. In the quote on the next slide, Lady Arden went on to explain that the effect of that known purpose for a liquidated damages clause is to provide an accrued right which the law protects at termination. That is to be taken as being well known, such that parties don't need to make express provision for how the clause is to operate at termination. So while it's been the case that since the Court of Appeal judgment, a number of institutions have considered, and some, like the NEC, have undertaken the rewriting of their standard form terms to make express provision for termination with respect to liquidated damages, the Supreme Court decision makes clear that wasn't necessary and is not necessary for the future. Now, with the general approach now firmly back in line with the orthodoxy, it's worth considering, I suggest, what scope there is to achieve different results, because I think that's the area where parties will now work, the orthodoxy having been restored. The Supreme Court made clear that it is open to parties to agree different results or a different outcome, though clear words will be required to unseat the generally understood approach to liquidated damages clauses, which have been set out in those judgments in the quotes I've given. And while the Supreme Court were, rightly in my view, dismissive of categorisation, the Court of Appeal categories do provide a handy way to look at this question, I suggest. That is what the parties might choose as an alternative. So looking at the category 1 in the Court of Appeals language, on the next slide, please. As I've said, clear words are required, but in principle, parties are able to agree in their contract to achieve a result which extinguishes liquidated damages that might have accrued, or to provide for liquidated damages not to accrue at all until completion of all the works. Though quite why they do so, I have to say I'm not clear. There are some examples of these sorts of clauses, and we found these in our research for the Supreme Court appeal. And these are in 2 Asian shipbuilding contracts, not ones that we'll see very often, I accept, in domestic construction engineering, but they do provide some examples. The two standard form contracts used in shipbuilding, often in Korea and Japan and China, provide for liquidated damages to be wiped away at the point of termination if buyer terminates the hull contract, the building contract, prior to delivery of the hull. But I'd suggest that these are examples of quite a different proposition. These are examples of agreed rescission, where the contract is wiped away from the very beginning. And it's logical, it seems to me, in those circumstances, that if you a contract to achieve that result, the hull gets handed back to the buyer and the buyer takes all its money back, then you have to settle up as between the parties with respect to liquidated damages. Now, it's easy to see how that works when you're building something to be handed over. Less easy to see how or why parties might want to do that in the context of a building or engineering contract after you've broken ground. But at least in principle, the sort of Supreme Court recognised that the parties can agree to do that. On the next slide, I consider briefly Category 3, which I said I'd come back to. The Category 3 cases, which I've listed, the 2 English cases there, that's Hall and van der Heyden and GPP in Bigfield, were TCC cases. They were both decided, the first one by Mr. Justice Coulson, as he then was, without the presence of, in the case of Hall and van der Heyden, rather, without the presence of both parties. It was a case decided having heard submissions only from the claimant. There's a similar case in Hong Kong called Creststream and Potter Design, which follows Hall and van der Heyden and was also decided in the absence of both parties. Now, in the light of what the Supreme Court has said, this principle is to be doubted, I suggest. The English law is that entitlement extends to termination, entitlement to liquidated damages extends to termination, but not beyond. Although, I think as Lady Arden has indicated, that is something which can be agreed between the parties otherwise. There's no reason why, and if an employer can negotiate itself into that position, liquidated damages can't be agreed to apply after termination, seems to me. The concept of post-termination provision, either for limitation of loss or for requirements for positive acts to be taken, is now well known, and one sees this in construction, engineering, infrastructure and outsourcing contracts for provision for limitation of damages or for termination assistance or positive handover duties. Now, while the exact legal analysis of those types of clauses is often difficult, they are recognised and enforced. And it seems to me, at least in principle, that parties may now write contracts which contain terms that provide for liquidated damages to be agreed to be payable post-termination. They're not easy ones to write, but the Supreme Court's decision does at least permit that to happen. That's been rather cantered through where we've got to. Rob's now going to take you through the other part of the case with respect to limitation of liability clauses.
Thank you, James. The Supreme Court's decision in PTT on limitation of liability provisions in the CTRM contract is much less talked about in the market than the liquidated damages decision, but I think is worth equal consideration. A central obligation in delivery of the contract was the obligation to exercise reasonable skill and care, and that's set out in Article 12.1, as you can see on the screen. And much of the inquiry at first instance in the TCC was whether that obligation was breached, and Mrs. Justice Jeff had found that it was in a number of respects. The contract, however, also contained, later in the same article, a limitation of liability clause, and that's on the next slide. This limited Triple Point's liability to amounts actually paid to it for services or deliverables related to the breach, save for certain exceptions. And one of those exceptions to the cap, as you can see on the screen, is any liability resulting from fraud, negligence, gross negligence, or willful misconduct of the contractor or any of its officers, employees, or agents. A key argument at each stage of proceedings, therefore, was whether Triple Point's breaches of its obligations to exercise reasonable care and skill triggered this exception to the cap. The question was a valuable one. The amount actually paid to Triple Point, the amount paid to Triple Point up to the point of termination of the contract was just over $1 million, whereas the total damages claimed were well in excess of $10 million. If you turn to the next slide, you'll see that Mrs. Justice Jefford in the TCC recognised that her findings on breach of Article 12.1 would, in common legal language, be called negligence, being a failure to exercise care and skill. However, she had concerns that the overall effect of the limitation of liability would be severely curtailed if Article 12.3 accepted negligence as used in the common sense. Triple Point argued that if negligence was interpreted in this way, the effect of the carve-out would be to drive a coach and horses through the provision, making it meaningless. This was because, they argued, most, if not all, of Triple Point's obligations required the exercise of reasonable care and skill. The judge recognised the tension between the normal meaning of negligence and the coach and horses point raised by Triple Point, and found that the parties cannot have intended to exclude from the limitation on liability the breach of the principal obligation appearing in the same clause. She therefore found that the exception for negligence must apply to something else, whether the breach of a duty of care in tort, other than a concurrent duty, if one exists, or its tie equivalent. The reference to tie equivalent there is because the contract was mainly carried out in Thailand, where PTT are based. So on to the Court of Appeal in the next slide. They upheld the TCC judgment on clause 12.3, and in doing so effectively again agreed with Triple Point's coach and horses argument, finding that PTT's construction would take away almost the entire protection of the cap and depriving Article 12.3 of practical effect. They said, therefore, that the reference to negligence in 12.3 had to be a reference to a freestanding tortious act of negligence. By way of an example of what that could be in their mind, Sir Rupert Jackson suggested that perhaps might be a Triple Point electrician leaving exposed wires that caused personal injury. So we found ourselves in the Supreme Court arguing the point for a third time. And as you can see from the quotes on the next slide, the court accepted our arguments that the lower courts had strained too far in seeking to apply an unnaturally narrow and specific interpretation of negligence to the words at Article 12.3. It accepted too that this effectively rewrote the parties' bargain and did not sufficiently consider the broader contractual matrix, the breadth of obligations under the contract, the nature of the works, and the appropriate tenets of contractual interpretation. One of the key cases relied upon was the House of Lords decision in Photo Production v Securicor, indicating that the courts should not seek to second guess the extent to which parties either extend or limit the scope of a limitation clause. However, as you'll see from the next slide, the ruling on this issue was not a unanimous one. Lord Sales, with whom Lord Hodge agreed, set out his dissenting views at paragraphs 124 to 127 of the judgment. We don't have time to go into the details here, but Lord Sales essentially agreed with the four judges before him. And as per the quote on this slide, it was the coach and horses point again that remained key. Lord Sales was concerned that giving negligence its natural and ordinary meaning appeared to undo what he considered the parties had intended to achieve by way of the cap on damages. So where does this take us? We should remind ourselves that Article 12.3 is a bespoke clause, and the detailed construction of its terms has limited wider relevance. I think that if we turn to slide 19, if we're counting the numbers as well, it's also worth remembering that 6 out of the 9 judges that looked at the point decided that the negligence exception to the cap was not triggered. That said, there are some important takeaways from the court's judgment. The reasoning of Lady Arden in particular underlines the importance of full textual and contextual analysis. that being a specific but informative application of Wood v Capita. The reasoning set out by Lord Leggatt, who was with Lady Arden in the 3-2 majority on the point, is perhaps worth the closest read, and that may signal a future direction for the long-running re-evaluation of English common law approach to the interpretation of limitation clauses. As Lord Leggatt's analysis of the development of English law in this area set out, a party is not assumed to give up valuable legal rights without clear words, and the more valuable the right, the clearer the language will need to be. In Lord Leggatt's words, the modern view is to recognise that commercial parties are free to make their own bargains and allocate risks as they think fit. The task of the court is to interpret the words used fairly, applying the ordinary methods of contractual interpretation. It, of course, sounds very simple when it's put like that, but as this case suggests, and the two appeals showed, it's not always so. On that final note, I'll hand over to Barry, who's going to talk on another WFW case, Toppan Holdings and Simply Construct.
Thanks very much, Rob and James. So in this part of the webinar, we're going to look at the case of Toppan and Simply and consider its implications for construction projects and real estate transactions. So the central issue in this case was whether a construction contract attached to a collateral warranty under the meaning of the Construction Act. And that matters because construction contracts attach a right of adjudication, which means that disputes can be decided quickly and more cost effectively than court proceedings. The case is important because up to now, collateral warranties may be construction contracts dependent on their terms. The court has now emphasized that the timing of the execution of collateral warranties as paramount in construing whether or not collateral warranties are capable of being adjudicated upon.
Thank you, Barry. In terms of the legal context to this case and to warranties, obviously there are various interested parties to a real estate transaction or to a construction project, and an underlying and a central focus of those interested parties is to have a directly enforceable right of action, and particularly in respect of defects, so that that party has security over the value of the asset. Now, prior to the 1990s, the law of tort offered that route where there was no contractual link between parties. One could sue for economic loss consequent upon physical damage to buildings. But that, since the 1990s, by way of tort, has been restricted significantly. So arising out of that, collateral warranties were introduced really to provide that direct contractual link between those who would acquire the asset, such as a future purchaser, or those with use of the asset, such as a tenant, so that they had specifically enforceable rights against the building contractor for latent defects. So that really sets the context. And as Barry has said, a practical importance is that these collateral warranties typically relate to the obligations of the building contractor under the building contract. So they relate to a construction contract. And the practical significance in dispute resolution terms, at least on these issues, is that, is there a right to adjudicate? Is the collateral warranty itself a construction contract? So with that background in mind, we'll turn back to Barry, who will take you through the facts of this case.
So the facts are typical of what's found on many construction and real estate transactions, and it involves the relationship between a landlord, a tenant, and a contractor. Particularly in relation to this case, the first claimant was the landlord of the luxury care home in London. It was built by a contractor, Simply Construct. Following completion of the works, Simply's building contract was novated to the landlord. That's not an unusual situation. And that established a contractual link between the landlord and the contractor. Subsequently, the care home was let to a tenant operator. Simply did not initially provide a collateral warranty to the benefit of the tenant. Following completion of the construction works, defects were identified in the care home which required remedial works. and certain losses from carrying out those remedial works were incurred by the landlord and certain losses were incurred by the tenant. So this meant that both the landlord and the tenant required contractual links to sue. So the landlord was able to adjudicate its dispute under the building contract, which had been novated to the landlord, but there was no contractual link between the contractor and the tenant. That link was subsequently procured by way of a collateral warranty obtained as a result of specific performance proceedings having been issued. And that collateral warranty provided the contractual link that enabled the tenant to sue the contractor. Adjudication proceedings subsequently took place, and the result was that sums were ordered to be paid by the contractor to the landlord and to the tenant. When the contractor didn't pay the sums awarded, enforcement proceedings were issued in the High Court, and the contractor defended the enforcement proceedings brought by the tenant on grounds of jurisdiction, namely that the tenant didn't have the right to adjudicate its disputes under the collateral warranty because the collateral warranty wasn't a construction contract under the Act. So we'll focus in the remainder of this presentation on the tenant aspects of the judgment. The landlord aspects are not as relevant because that decision was enforced by the courts. So now back to Tom for a review of the decision itself.
Thanks, Barry. So as Barry's alluded to, the exercise for the court was one of contractual interpretation. Was the tenant warranty a contract for the carrying out of construction operations? The court considered some guidance which had been provided in a previous case called Parkwood. And in that case, there were 3 points of principle. First, that a construction contract may be retrospective in effect and still fall within the Act. It doesn't need to be wholly or even partly prospective. Secondly, that the Act was intended by Parliament to have a wide ambit and a wide effect. And thirdly, that where the contract is for the carrying out of construction operations, it will invariably fall under the Act if it provides for that in its express terms. There was a further comment by way of obiter dicta in that previous case of Parkwood, which said that an indicator against a warranty being a construction contract would be if all the works had been completed and if the contractor was simply warranting a past state of affairs akin to a manufacturer's warranty. In this case, as a matter of fact, as Barry has set out, the tenant warranty was executed after works had been completed and after remedial works had been finished. So although this particular warranty contained express terms for the past carrying out of construction operations and also to the future carrying out of construction operations, so really falling within the third point of principle within Parkwood, the judge placed great weight on the fact that the warranty had not been signed until after works had completed. So although it included express language as to the carrying out of construction operations and prima facie within the scope of the Act, the warranty in fact could not relate to that because there were no further works to be done. The court also confirmed that although the warranty provided that the tenant acquired no greater rights under the warranty than would be available under the building contract, this didn't mean that the equivalent rights under that contract extended to the right to adjudicate under the building contract. So for all of those reasons, and most significantly, the date of signing of the warranty itself after practical completion, the judge held that construing that warranty, it was not a contract for the carrying out of construction operations. If we could have the next slide, please. Where does that leave us in terms of the legal implications? Well, there are two main points here. Obviously, as the law now stands as a result of this judgment, the court will look primarily to not just the terms of the warranty, but most significantly as to when that warranty was signed and entered into. That does raise some problems, chief of which it's very common, as many of us will be aware, to find construction contracts which are entered into either partway through the works or even after the works have been completed. And historically, as a matter of law, that's not posed a problem, because how the law deals with that is to find that there are obligations within that contract which are retroactive in effect. So although the contract has technically been entered into after the works, those obligations are deemed to have started from the outset of the works. The court wasn't persuaded by that argument, though, in this case. So we have the timing point. And the second interesting feature legally is the legal uncertainty which arises on this analysis, focusing on the date of execution. How does that impact upon the types of dispute which may or may not be referable to adjudication? If, for example, we have a warranty which is signed and executed halfway through the works, does that mean that the works prior to the warranty having been signed are not capable of being referred to adjudication, but only the future works? The judgment does leave uncertainty in that area as well. So those are two key areas of legal implications, but there are significant practical implications as well, which Barry will discuss now.
Thank you, Tom. So in terms of the practical implications of the judgment, we're left in a position where we have a two-tier system that applies for collateral warranties. And in particular, the judgment is going to make it more difficult to procure collateral warranties. So particularly parties providing warranties may be reluctant to provide them before practical completion. Now, this is contrary to the wide ambit of the Act and the desire that disputes are decided quickly and cost effectively. And whilst it's often said that a job is not complete until all the paperwork is done, this judgment is going to make it more difficult to put in place the paperwork that is required on construction contracts prior to them completing. And this will impact on my second point, which is the difficulty in restructuring construction projects and real estate transactions in the event that all the construction documents are not in place. So by disincentivizing parties to provide collateral warranties, it's going to make it more difficult to restructure jobs that run into difficulties. So for example, if a building contractor becomes insolvent on a live project, the employer may exercise its rights under the contract to engage the subcontractors directly. And in that scenario, the party that steps in will benefit for a warranty for the works that's been carried out for the insolvent or dissolved building contractor up to the date of step in. And then after step in, there will be either a new contract, a new warranty for the works that are then carried out after that. The risk with collateral warranties not being put in place until after practical completion takes place is that the party stepping in may not then benefit from that collateral warranty for works up to that point. And so if they then want to obtain the benefit of a warranty for the entire project, the party stepping in may be left with no alternative but to step in under the subcontract, and that may mean they have to take on the subcontract liabilities. And clearly that's not going to be commercially advantageous to any party seeking to restructure a job. So it raises a lot of questions as to what will happen in practice if these collateral warranties are not put in place. And also we've got the impact of the judgment on certain real estate transactions. So some transactions, such as forward funding commitments, forward funding agreements, they're structured so that someone else carries out the development works. And then the third party beneficiary who's funding that development will then obtain the collateral warranties after practical completion is achieved when the building is handed over. So in this scenario, unless those warranties are procured on the live project, the party that's subject to that forward funding commitment, forward funding agreement, will be in a position where it only receives warranties that are akin to a manufacturer's guarantee. There'll be second-class warranties that won't attach statutory adjudication rights. And it also creates uncertainty as to what's the relevant date for practical completion, because it's not uncommon on construction projects for various subcontract packages to have their own practical completion dates. So does the judgment mean that if there's an earlier practical completion date in relation to a subcontract package, that's the relevant date by which the statutory adjudication rights apply? Or is it the rights attach to practical completion of the entire project? So it leaves a lot of questions unanswered that practitioners are now going to need to think through quite carefully. Tom.
Thank you, Barry. If we could have the next slide. So just to really summarize, so I'll deal with the position if you are a beneficiary of a collateral warranty, and Barry will deal with the position if you are providing a warranty. So just some practical points. If you're the beneficiary or you're meant to be receiving this warranty, obviously carry out an audit to understand the rights that you've already acquired, and obtain, so far as possible, the collateral warranties before practical completion has occurred, if you want to try and acquire and hold on to that statutory adjudication right, which, as Barry has said, is a very valuable practical right, cost effectively and promptly to adjudicate these disputes. And finally, one has to consider the wording of collateral warranties and how this may now need to be adjusted following the decision itself, to provide in terms for dispute resolution clauses and specific adjudication clauses. Barry, I'll turn over to you finally, if I may, on the other side of the fence, if you're providing a warranty.
So if you're providing a warranty, then essentially you need to understandably view with some caution as to whether you'd want to provide that warranty prior to practical completion. Because if you provide that warranty before practical completion occurs, that will be a warranty to which statutory adjudication rights attach. One may want to make it more difficult to for those rights to acquire by providing the warranty only after the work completes. And equally, if you're being asked then to provide a warranty that's in different terms to that's already agreed, it's important to take advice. So it's often been said by some commentators as a result of this decision that what parties need to do is to include the relevant dispute resolution procedures in the warranty. But in reality, the warranties that are being procured would be subject to a template attached to a building contract that may have been entered into many years ago. So some parties, some employers may now want to seek to renegotiate those templates by clarifying the adjudication provisions within the warranty itself, rather than within the underlying building contract to which the warranty relates. But of course, that's not the template that's been agreed. So if a party asked to provide a warranty is presented with a document that's different to the template attached to the original building contract, take advice, because there may not be any obligation to provide a warranty in those amended terms. That's all we have time for by way of a summary of the judgment. We will take questions later. Now we hand over to Ryland for a review on the labour and material shortage.
Thank you very much, Barry and Tom, and thank you to everybody for joining our seminar. So the topic of my presentation is the impact of the shortage of construction materials and labour. And there's no doubt that I've got the most emotive of all the topics. For those of you based in the UK, you will have undoubtedly had problems if you have a car trying to get your petrol over the last few days and even weeks. And that continues to be a problem. So I promise not to spend too much time talking about the lack of petrol. If we can move on to the next slide, what I wanted to start with, the next one, please, is an overview of the effect of this shortage. Now, the obvious points to make are that, first of all, in most cases, we're talking about an increase in cost. And an increase in cost and a lack of supply of both materials and labour is causing delay. And it's causing delay on projects globally. This is not just a UK problem, and it is a very complex problem when you start to look at the causes of these issues. The effect of it is that the risk is increasing for the subcontractors and the contractors that are tied into agreements whereby they have to provide things at a certain cost or price and within certain timeframes that they may not now be able to meet. And obviously that has an impact upon their cash flow. And in many cases, we're seeing parties being tipped into insolvency. So it couldn't be more serious. If we look at what the Construction Leadership Council have recently said, they're saying that the basic trends of the last 6 months remain, with global demand far in excess of supply, leading to product shortages, rapid and sustained price inflation, long lead times, and uncertainty regarding deliveries. It's also clear that the global shipping industry is far from recovered from the disruption caused by the coronavirus pandemic, with congested shipping routes, container cancellations, and higher costs still evident. And I've got a quote here also from the Chartered Institute of Purchasing and Supply, who are saying that 80% of companies reported longer lead times and a shortage of construction supplies, particularly in respect of materials sourced from the EU. So on the next slide, what I've tried to capture, and I'll mention briefly, are the contributing factors. First of all, we've got people in their homes who've been subject of lockdown, thinking about home improvements. I'm one of those, trying to improve my garden and thinking about changes to the house. And that has, albeit a sort of small consideration, has led to an increase in prices and shortage of materials that would have otherwise gone to other projects. The next thing is the reduction in productivity as a result of disrupted manufacturing lines and logistics lines. So where lockdowns have occurred more locally, globally, they have obviously impacted upon the supply of materials across the board, but also productivity itself has been broken down because of the stop-start nature of working over the last 2 years. More recently in the UK, we can see that summer construction output is down 1.3%. Now, that's not because of lockdown, that's because of these shortages. The global logistics issues they come into sharp focus when you think about the problem with the Evergreen ship that was trapped in the Suez Canal. That clearly had an impact upon supply chains, and it just shows that things far away or that seem far away from us can have consequences upon things that are very much local. The shortage of HGV drivers, as I opened and mentioned, in terms of the supply of petrol, is something again that brings it into sharp focus. The causes of that are somewhat controversial and people don't necessarily agree, but there's clear evidence to suggest that Brexit has a part to play in that. And then the pressure to decarbonize the construction industry is another factor which is not so obvious. Then we have extreme weather events that are perhaps caused by the fact that the environment and global warming is happening. And in particular, we've got an increase in pests and fires, for example, in particular in Europe and America and in Australia and other places around the world. You can see extreme weather becoming a more regular occurrence. So prices of timber, for example, have increased by 80% since November 2020. So then you look at whether there's issues of policy and whether policy has changed or should change. 80% of our timber comes is imported, and half of that's from Sweden. And in Sweden, there's a massive debate at the moment about whether or not it's actually good to encourage the use of timber rather than, for example, steel in construction. And in the UK, we're trying to react to that by trebling the tree planting by 2024. So clearly there's important debates to be had around the contributing factors and how to mitigate those. Next slide, please. So how do you protect your company or your assets? The most important point here is to look at the form of contract that's being agreed for the construction project. Now, if we look at standard forms of contract, there are essentially 4 types, and there are variations upon these themes that exist, and of course, bespoke contracts. But starting with the most common in the UK market, at least, the lump sum contract. Now, clearly, when you agree a lump sum with a contractor or subcontractor, that means that they are taking the risk, A, in respect of any increase in prices for the materials that they've priced within their lump sum, and B, in relation to the availability of labour to meet certain dates, if there are dates that have been agreed in relation to completion of the works. But what you can also have is a lump sum contract with fluctuations, provisions, which I suggest is something that parties should look at in more detail going forward, and I'll come back to that point. There are three others which, in simple terms, do address or can take stock of changes in respect of the supply of materials and labour. So the next is a target cost contract, for example, the NEC contract options C and D. And in those contracts, you create a target cost based upon the prices at the time the contract's entered into. And if the contractor exceeds that target price, then he shares in the pain of that overspend. And in some cases, if it's extreme, they could end up owing money to a client. And if they save money, then ultimately there is a gain to be had. So the adjustments are taken account of in respect of the actual prices of materials at the time that they are procured. Thirdly, you've got remeasurable contracts where effectively you just have approximate quantities and rates, and then they're applied at the time that they're incurred. So that again would take account of fluctuations in the market. And then finally, a cost reimbursable contract whereby the money that's spent on the project is reimbursed plus an overhead and profit, which again would capture these fluctuations. That doesn't obviously deal with issues of delay necessarily, but it does capture the cost. So when we're talking about fluctuations, it seems to me that there are three key things that need to be covered. First of all, changes in the law and taxation as a result of whether it's COVID or Brexit, but ultimately your contract should deal with this head on. And if we're talking about customs and excise, obviously that can feed into fluctuations in prices. Next, the cost of labour, transportation and materials specifically. And of course, contracts could, if we wanted them to, deal with each of those specifically and individually. And then finally, something that's not necessarily captured in the standard forms of contracts that are available at least are increases in head office and administrative costs. Next slide, please. So how do you protect your company or asset? Well, first of all, you've got to consider what type of contract you're in. If you have a contract with fluctuation provisions, my suggestion is that the standard forms of contract that are out there are not really fit for purpose. It's clear to me that you need to do quite a bit of engineering to make sure that your obligations are protected. And you have to sometimes be quite creative, as I'll come on to, in terms of how you can pursue claims in respect of these issues. But ultimately, these contracts don't really deal with these things properly. An example of that is if you look at the NEC 4 contract, the new engineering contract, there is a secondary option X1 which can be used whereby fluctuations in the market can be captured. However, those provisions are often linked to either inflation rates or retail price index changes or other indices. Now, the problem with that is whilst the retail price index may change the overall cost of things, it doesn't necessarily reflect individual changes. So you've got to remember that most contractors, particularly in the UK, are running on 2 to 5% profit margins, and subcontractors similarly. So it doesn't take much to push what would be a profitable project into one that's simply financially unviable. So my suggestion would be that you can change those provisions, make them more bespoke. If you look at the JCT contract by comparison, it talks about in 2.2.1, all materials and goods for the work shall, so far as procurable, be of the kinds and standards described in the contract. So the important provision there is so far as procurable. There is a debate over whether certain materials are even procurable at all. And that the answer to that question will be determined by the context. So is the contract due to be complete within 4 weeks? And if so, we used to be able to get steel within 2 to 4 weeks. We now have to wait sometimes 3 months, even a year for certain steel jointing to be manufactured and delivered. So clearly, in some cases under the JCT, materials won't be procurable as specified in the contract. So the consequence then is to look at other provisions of the contract and say, well, what happens next? And what should happen next is that there's a sensible discussion between the contractor and the employer, and the employer should be giving an instruction to replace those materials if they can. And that would then fall under an instruction, which could lead to an extension of time and or loss and expense. And if they don't give that instruction, you could be looking at a remedy under 226(6), insofar as it might be considered an impediment or an act of prevention by the employer in failing to give that instruction. Next slide, please. So if you're already in contract and you've got no fluctuation provisions, then as I say, the contractors and the subcontractors are stuck. Now, does that mean that employers or main contractors should be pushing those parties to the financial brink? The answer to that must be no. I'm minded of the fairy tale of the golden goose and the fact that we shouldn't strangle that golden goose. Ultimately, if you push a company into administration because they can't provide materials in time or at an agreed rate, think about who you're going to replace them with. Surely that party is going to face the same problems unless there are very different propositions. So be careful what you wish for. Can you rely upon force majeure? Now, force majeure is not an English common law principle. It actually derives from obviously a French phrase, but it has older roots in Roman law. And the simple fact is, under English law, force majeure is what you say it is in the contract. In other words, we can define what it means. So we could say that it covers COVID. We could say that it covers a shortage of materials and labours, but the question will be is how you measure those things. So it's a question of looking at the contract and seeing how that is defined, if at all. The next thing to consider with force majeure is whether or not something is reasonably foreseeable at the time the contract was entered into. And if it was, it would be considered probably unwise to pursue a claim for force majeure. So what can you do practically? Well, my suggestion is what you can do is discuss the options in relation to perhaps delaying parts of the work or all of the work, suspending the work, reprogramming the work by agreement. The key to resolving these problems where the provisions in the contracts aren't fit for purpose is by way of collaboration and being realistic. So as a result of those things, please don't forget that there's an important step to negotiate new terms and clauses and capture agreements in a very clear way, which of course you'd need legal advice on. So look at the different various scenarios and potential outcomes for these problems, and be realistic and sit down around a table and talk about how to resolve them. But in the meantime, please don't forget you have to comply with the contractual requirements in your contract as they stand, because you don't want to lose rights or give away certain benefits. So there are changes, there are delays, and there are suspensions that may need to happen. You need to look at the contract provisions and decide whether there are notices to be given, what substantiations to be provided, how long you can suspend or delay for, and what are the consequences of those changes. Beware, however, of the risk of wrongful termination as well, because it may be that the simple answer is to actually terminate a contract or a subcontract, but don't do that without a firm right under your contract for doing so. Otherwise, you may face a wrongful termination or repudiation argument, which is a very common and complex and often a very aggressive and difficult dispute to resolve. And then finally, obviously, you have to consider the obligations and also the liabilities in relation to delay and or liquidated damages. As we've heard from the chaps earlier, that's a changing area of law in itself. The next slide, please. So alternative materials is one way around the lack of materials, but obviously with labour it's not so easy. So in terms of materials itself, the suggestion I would make here is that one of the things you can do is to purchase materials in advance and or stockpile. I'm sure people on the seminar today have heard about the stockpiling of materials. Now, of course, that can have a negative effect on everybody else, and it can mean that only the larger, more financially stable parties can actually do that. But so be it. I mean, it's a capitalist markets that we're talking about. So that's one solution, is to stockpile certain materials if appropriate, but don't forget the storage costs and the logistics involved in doing so. If you don't have the money to do that, then there is perhaps a conversation to be had with funders, or indeed looking at security for advanced purchases, which is another way around being able to stockpile appropriate materials. And then in terms of contracts, it's my firm view that parties should be looking at making fairly wholesale changes to your contracts. And I'm talking about amendments to standard forms as part of that. And what I would like to see is more transparency about these fluctuations and changes in the market and in prices. I'd like to see earlier communication and early warning mechanisms, which you do in fact see in the NEC contract, for example. I'd like to see a base date and data being used as a measuring yardstick for changes in the availability of labour, as well as the cost of materials. Fluctuation provisions for specific materials, I think, is the key. If the retail price index says that the fluctuations should be taken into account and prices go up by 5%, that's not going to cover a contract that is based upon 50% of timber, where timber's gone up by 80% since last November. It's simply not fit for purpose. So look at the materials that are specifically required in the contract, break those down, and then look at the specific risks in relation to each of them and the labour, and then design the contractual provisions so that they are appropriate and can deal with fluctuations in relation to specific materials. I think you can have simplified replacement material and change scope provisions, because if you can't get hold of certain materials, then perhaps you need a design change so that you can have other options. And there needs to be more flexibility in the contracts for doing that. Responsibility for changes in law and in the tax that's attracted is something else that needs to be covered more clearly. The parties need flexibility, perhaps more flexibility now, to suspend or delay works, and dealing with the allocation of cost in relation to those things. And as a consequence, possibly more flexibility around termination rights or the replacement of certain subcontractors and suppliers who simply can't service or supply materials within the agreed timeframes. So more flexibility is ultimately the theme here. And of course, you're going to need very carefully crafted provisions to achieve these things. Next slide, please. So in summary, the first thing that needs to happen is we need to sit around the table and consider the likely impact of changes in prices and a lack of labour for the specific contract or project. Then we need to be realistic and look at the programs that are in place and the cost plans that are in place, and have a communication at an early stage with our counterparts, sit around a table, discuss the solutions, including changes to completion dates, realistic variations, changes to prices, scope, and or potentially putting things off or suspending them for a period. If you've got existing contracts, then you need to undertake a fairly thorough audit of the obligations and rights that exist under it, looking at things like changes in the law, fluctuation provisions if you have them and the limitations of them, provisions for force majeure, provisions for delay and or loss and expense in relation to these problems, because it's clear that they are not going away. Remember the golden goose, don't push parties too far. And obviously, if you have an opportunity now for newer contracts, then the same things apply. my list on the previous slide is just a starting point in relation to the amendments I think are absolutely necessary now to your forms of contract. So update your contracts with practical and bespoke provisions, and obviously you're going to need to take legal advice, and where better to take that advice from than a fantastic firm like Watson, Farley and Williams. So Rishi Sunak said, I think yesterday, that there's no magic wand for this, but call me Houdini, but I think that there are some very good legitimate solutions there that are available to protect your companies and assets. So on that note, I will pass back to Rebecca, and I understand we're going to open up for Q&A.
Hi, well, thank you everybody for the interesting discussion. Lots to think about. We're going to extend by about 10 to 15 minutes to take some questions, and so if anybody would like to stay on, you're welcome to do so. So I'm going to take it in order of the presentations, actually. So we've got a question on triple point, and it relates to the liability cap. It's really seeking clarification. The question is that in relation to the negligence exception, in relation to the liability cap, was the conclusion of the Supreme Court that where negligence is an exception to the liability cap in, say, a pure design contract, then effectively the cap would be of little or no effect? Rob, since you discussed that particular aspect of the judgment, would you like to take that question?
Absolutely. I think I'll start, and I'll give the questioner the benefit of James's views as well once I've given a first answer. But I think it's a good question. Firstly, I think the thing to bear in mind is the contract that we were looking at in the PTT case was not a pure design contract. It's more akin to a design, build and operate contract. And part of the argument before the Supreme Court was that the contract we were looking at included various obligations that did not require the exercise of reasonable skill and care. Also, we were looking at a bespoke contract, so we need to be careful not to draw too many generalizations from its conclusions. However, dealing with the question itself, if we were to be looking at a pure design contract, then I think the result might well have been very different. As the coach and horses argument, as I was putting it earlier, would have had much more weight, given the fact that all obligations essentially under that contract would require the exercise of reasonable skill and care. That said, Lady Arden and Lord Legate's judgments in particular still suggest that you need to interpret the words used on the page, and negligence has a straightforward meaning that most people will accept. So if the limitation provision in a pure design contract was similar to that we were looking at 12.3 in the PTT case, then I think there would still be a clear conflict between that and the obligations elsewhere in the contract that would need to be resolved. And that's still a difficult question, and one for which I'm going to pass over to James to take the next bit.
Thanks for that. I think, as Rob points out, I mean, the argument was based primarily upon the fact we weren't dealing with a pure design contract, and this was a contract which came in at least two parts. And the point we were making was this is the fact that the case itself was focused on the implementation stage, where design and consultancy obligations, those which carried obligations to exercise reasonable skill and care, were paramount, shouldn't be allowed to sort of overcome, if you like, or be given priority of the fact that the rest of the contract, which was going to last for years, was basically a contract for software maintenance, support and licensing during the operational period. I think, though, if one were to sort of remove ourselves from the facts of PTT and say, right, let's hypothesize a situation in which an architect's contract or an engineer's contract is in question, and one is looking at a case a bit like the Arab case that Rupert Jackson looked at a few years ago, and there's a limitation on liability there, but for some reason there's an exception written a bit like the PTT exception, saying limitation on liability to X amount paid or whatever it happens to be, but not in respect of negligence, then as Rob points out, there'd be a direct conflict there. The reasoning of Lady Arden and Lord Leggett, and particularly Lord Leggett, I think, who said that obviously clear words are required, and parties are not to be taken to have given up valuable rights unless clear words are used. I think that would produce a tension there, because what one has on its face is two sets of clear words. One is limitation of liability, and the other, which conflicts, is but not in respect of all the obligations that exist. I think at that point, the argument probably would run that something's gone wrong with the contract. And I think probably the route to deal with that scenario would be to look for rectification. So what one wouldn't be doing is trying to construe the contract on the straight words. I think the approach you would take there is to say, well, there's clearly an ambiguity there, and you look for rectification and ask the court to review the words and effectively change the contract for you. Because I don't think you can otherwise deal with the conflict.
Okay, thanks very much, Rob and James. The next question is a question relating to Toppan. I'm, as you know, very interested in this case because my practical experience has been that collateral warranties are actually quite difficult to chase down, and I think there will be some wily parties out there that might take their sweet time to execute them. The question is, what are the implications of the Toppan decision on third-party rights, notices, and provisions? Tom, you're off mute, so
no, it's
you take that question.
Thanks, Rebecca. It's a great question. In our case, I'd say that there was no direct implications. On the 2011 JCT design and build that we had in our case, the third-party rights provisions had all been specifically excluded and stricken off. But indirectly, I guess, the decision does render the collateral warranty route of slightly less practical utility. But third-party rights and adjudication, which is what we're talking about, obviously have their own difficulties. You might recall there was a case a few years ago, Barclays and Hurley Palmer, which dealt with whether if you have the benefit of a third-party rights provision, you could adjudicate anywhere. And I think Mr. Justice Ramsey said in that case that you couldn't. So yes, whilst our decision in Toppan makes collateral warranties of slightly less practical attraction, I still think, for this type of point, i.e. the ability to adjudicate, they're still the go-to. So yeah, no direct implications as far as I'm concerned. But Barry, if you wanted to add anything, please go ahead.
No, but I think, just coming back really to the point that we discussed earlier in terms of, what are you obtaining when you achieve a collateral warranty? So for example, a piling contractor who provides a warranty and carries out its works at the start of a project, we may find that piling contractor, there isn't a right of adjudication attached to the piling warranty, because the piling warranty was given prior to practical completion of the works, but after practical completion of the piling subcontract. So there's a lot of uncertainty here, and there are a number of questions that remain to be resolved, including the wider impact generally on the decision, and practitioners will no doubt continue to work through that.
So in the interests of fairness, we've got time for one more question. I'm going to direct this one to Ryland. The question is, in terms of fluctuation, does the recent change to the NCI rates, that is the health and social care levy, class as an event under the change of law clause relating to taxation? You happy to take that one, Ryland?
Yes, very happy. I mean, I think that the question will be, does the change arise as a direct result of a change in the law? And it is, it's been difficult throughout the lockdown and the pandemic to actually get to the bottom of that question sometimes, because there are regulations, there are directives that come from the government, and not all of them are underpinned by law. And so it would really be a strict interpretation of whether there is actually an enactment of a new law or a change of the law itself to answer whether that ultimately would lead to something that you could then claim for under the contract. And then there's a question of whether it's post the base date in the contract, because most contract provisions that say you can claim for a change of law would have to be something that's post that base date in the contract itself.
Thank you, Ryland. Well, I think we should finish up now. If there are any questions that remain unanswered, we will definitely respond to them. And of course, as I said earlier, you are welcome to reach out to any of the speakers. A big thank you to all of our speakers today for what was an interesting and very informative discussion. And obviously, a big thank you to everybody who took time to attend today.